behalf of myself, Bill Perry, our board of directors, all of our shareholders and team members, welcome today to our webinar on the CARES Act for legal professionals. Let me go to a few housekeeping issues before we get started. First of all, we are recording this webinar. You can replay the webinar on demand from Gunster's website. It's gunster.com/COVID-19. It will be available starting tomorrow morning. You're free to share that with others at your choosing. You can find additional information on our website concerning the CARES Act as well as other issues concerning COVID-19, and that website is gunster.com/COVID-19. There will be CLE credit available today if you apply for it, and we will send you an email with the credit information when it is approved. We've also created a dedicated COVID-19 inbox that we monitor regularly. If you email us at COVID-19@Gunster, GUNSTER.com, that's COVID-19@Gunster.com, we'll respond to those emails when you send them. The topics that we're going to cover today concern the CARES Act. I wanted to just give a brief overview before we go into today's presenters. The current state of affairs in Florida is that we have a caseload now of 20,601 confirmed COVID positive tests. That's up from the previous report of 18,494. We've had, unfortunately, 470 deaths. While those numbers are distressing, they are significantly less than other parts of the country. New York, for example, is at 190,000 folks who've tested positive. The number of hospitalizations in Florida in terms of admittances is actually going down, and predictions are that we will hit our peak in terms of folks who are testing positive sometime in the month of April. Recent reports out of the administration, Dr. Fauci and others, is that there are plans for some partial reopenings of business in May. We will have to see what happens with that. We are under various closure orders in Florida. You might have heard today that the president has announced that he will be deciding when the country reopens. That's partially true. He, of course, can give guidance, and the CDC can give guidance, but it's our local municipalities and our governor who have the closure orders which are in effect. And my colleague Jonathan Osborne in a moment will talk more about those closure orders. The United States Congress has passed several measures for relief concerning the COVID-19 virus. The most recent is the CARES Act, a $2.2 trillion, if not more, program to aid small businesses, healthcare providers, important industries, as well as local and state governments during this extraordinary time. That program offers sufficient help in the form of relief in terms of direct financial loans and payments, as well as important tax relief for businesses in our country. I'm going to turn it over to my colleague, Adi Rappaport. Adi is the chair of our tax department here at the Gunster Law Firm. He is a shareholder in our West Palm Beach office. He's going to talk about federal financial relief for businesses. That includes the Paycheck Protection Program, as well as the EIDL program, which is an existing program which has been expanded. Stands for the Economic Injury Disaster Loan Program. And he'll give you an update as to new guidance that's come out from the Small Business Administration and other departments of government as to how the CARES Act applies. And he's going to focus on that in terms of your needs and responsibilities as lawyers providing advice to clients concerning the CARES Act. So let me turn it over to Adi.
Thank you, George, and good afternoon, everyone. So my presentation will have two parts. The first part, I'll discuss federal loan programs that are available, including discussing some discrete issues that we've been evaluating in the last couple of weeks with respect to the Payroll Protection Program and the Economic Injury Disaster Loans Program. And I'll also discuss the recent release by the Fed of some information about the Main Street Loans Facility that's also authorized in the CARES Act. That's going to be about 10 minutes of my presentation, and then I have some comments about some tax benefits available under the CARES Act that you and your clients should consider. As an initial point, because this program is for practitioners, I'm not going to get into the details of the PPP loan program. I'm going to address some specific nuanced points, but if you want a more general discussion of the PPP program, I would encourage you to look at the webinar we posted a week ago on April 6th that contains some more general information and some other good information relating to employment law practices relating to this crisis. So first, a quick update on the Payroll Protection Program. It's been reported that as of the close of business on Friday, 710,000 loans have been approved for approximately $179.2 billion of loan assistance. In Florida, that is, the portion in Florida is 21,300 loans for about $6.35 billion. As you might be aware, the total amount appropriated under this program is $349 billion. So the loan approvals at this point are slightly more than half of the funds available. Anecdotally, while the loans have been approved, it appears that loan disbursements have not been broadly made. There are websites that have cropped up that request information from borrowers about the timing of their loan application and when loans have been dispersed. And from what I saw this morning, about 2.5% of the loans that have been applied for have now been funded. So there's going to be a ramp-up period as the money is dispersed. The guidance from the Treasury is that the loans must be dispersed within 10 days of approval. But as you might have read, there have been some glitches coming out the gate that are being corrected by the SBA and the Treasury. Specifically, lenders were concerned about the disbursement procedures and what documents to use, specifically promissory notes. And the SBA published guidance on that on Friday, so we expect these issues to be ironed out. The other point that George alluded to is there's been some discussions about increasing the funding for the PPP program. There was discussion last week of increasing funding by another $250 billion, and that is being hung up in Congress, so we'll see where that goes. Let's stay tuned on that. Next, I want to discuss a couple of certifications that exist on the loan application. So the week before last, the Treasury released a form loan application, and the loan application requires certain certifications from borrowers, and those certifications are actually required by the CARES Act. The first one I think practitioners should pay close attention to is the certification that states current economic conditions make the loan necessary to support ongoing operations. As you can readily tell, that's a very broad general statement. And I should point out that there's no defined terms associated with the certification. So we don't have specific guidance on the meaning of what current economic uncertainty means, or necessary, or support the ongoing operations. Certainly in talking to many clients over the last couple of weeks, certainly everyone can make the argument on planet Earth that they've been affected by COVID-19. But the question here, I think, is more nuanced with respect to each specific business that you are counseling. So it's not clear what current economic uncertainty means, but to give you maybe an indication, the part of the Act that talks about the employee retention credit that I'll mention later, it's a payroll tax credit, mentions that you need to have a reduction in gross receipts of more than 50% from the prior year 2019, to qualify for that benefit. So the question then arises, can you extrapolate from one to the other as to what the government may mean in terms of the economic harm that's taking place? And it's just not clear. So we're making certain recommendations for every applicant to prepare an internal analysis and presentation that addresses why your business needs to take the PPP loan. In my opinion, the analysis should include the company's current cash position and burn rate, including the maximum runway of when the business would run out of cash absent the PPP loan, discussion of the loss in revenue or anticipated loss in revenue due to current conditions, discussion of potential reduction in workforce or actual reduction in workforce, and other budgetary factors that you think may be relevant. This is a very qualitative facts and circumstances analysis, but we think it's very important and should be presented to the governing board of your business in connection with authorizing the loan. The bottom line is, I think you need to have a good answer as to why you borrowed the money, and the government certainly has serious tools to attack and investigate false claims on loan applications. The next certification I want to discuss is the one that certifies that the funds will be used to retain workers and maintain payroll or make mortgage interest payments, lease payments, and utility payments as specified under the PPP rules. So one question that's come up is, what happens if you've already laid off or furloughed a significant portion of your workforce? Does that mean you can just borrow the money based on the look-back calculation of the maximum loan amount and keep the money on hand for other potential uses that are typically allowed under the 7A program, which the PPP is an expansion of? The answer appears to be no. The SBA interim final rules that were issued on April 2nd provide that at least 75% of the PPP loan proceeds must be used for payroll costs. So I would advise that you carefully review the interim final rules and make some thoughtful determinations about whether to take the loan if you do not plan on rehiring your workforce after the loan is funded. There have been some questions about loan forgiveness. So if the loan is spent on payroll costs, mortgage interest, rent, and utilities, after 60 days after the loan is granted, you can apply for forgiveness. The nuance here is you have to spend the loan funds in the 8-week period following loan origination. So one of the complaints from small businesses is that the borrower has no control over when funds are dispersed, so you can't match the ramp up in your rehiring to when you want to spend the money. So a business that's shut down, like a restaurant, for instance, that maybe could use the money in June or July, has to use the money in the 8 weeks period, just paying employees to stay home instead of ramping up their business. So I'm not sure that's going to be fixed, but it's something to consider in terms of the timing of your application. It's a bit of a chicken and egg situation because the loan proceeds, the funds are first come, first serve, but you may not need the money until later on in the disbursement period. So maybe some clients are better off having the loan in May and June as opposed to mid-April. Another issue that's come up frequently is the discussion of the affiliation rules. So for applicants that have venture capital investors or private equity investors, or even angel or early round investors, there's an issue that your loan eligibility needs to be for less than 500 employees, and you could be aggregating or consolidating with affiliates. Affiliation is based on control, and control could include blocking rights that an investor may have in your operations. So if you have an investor, an outside investor, you should carefully review your governance documents and see if their blocking rights, or negative rights as they're called, could somehow cause the inclusion of other employers and bump you out of PPP eligibility. A few other quick points on the PPP program. You should be advised or advise your clients that the information about SBA 7A loans is subject to the Freedom of Information Act. So it's possible that when the loans are granted, the press or others may request information about the loan. The request probably will not include, or the deliverable from the SBA probably will not include the loan application, but it would certainly include the name of the borrower, how much they borrowed, and information of that sort. So I would go in with the expectation that your decision to borrow the money would be made public. And finally, I would be careful in advising your clients about limiting internal communication that may not be privileged. So for instance, an internal email that says we should definitely take the loan because it's free money would be a no-no. And so you should be mindful of the discussions you're having internally, including ones about certifications you're making, your plans to rehire employees, et cetera. That could all be relevant down the road. I'm going to move on to the Economic Injury Disaster Loans Program. That program is typically used when there's a tornado, earthquake, hurricane, and it is made available for businesses to fund working capital for a limited amount of time. The loan cap amount is $2 million, and the borrower must have a personal guarantee for any amount above $200,000. The CARES Act provides an emergency $10,000 grant that is forgivable. The issue that's come up in the past week is that it's been reported that the SBA is going to ration out the money that's been appropriated for this program, and the most that they're going to give any business is $15,000. So it's $15,000 per applicant. So there's some very limited utility now under the EIDL, and I think that's something worth monitoring in terms of deciding which benefit you're going to apply for. A quick note about the Main Street loan facilities. So last Thursday, the Board of Governors of the Federal Reserve System announced the framework for what's called the Main Street New Loan Facility and the Main Street Expanded Loan Facility. These programs make $600 billion of new credit available to eligible small businesses. These are businesses with fewer than 10,000 employees and less than $2.5 billion in revenues. So the eligibility standard is much broader than the PPP. And the PPP has indicated that firms that have taken advantage of the PPP program may also take out Main Street loans. The max loan facility on the new loan facility is $25 million. The max loan facility for the expanded loan facility is $150 million. And these amounts may be capped based on current borrower leverage or EBITDA thresholds. These loans will be made available through eligible lending institutions. And at the moment, there's no detail on how businesses apply. Now, one thing to understand is that borrowers under this program are going to be subject to certain operational restrictions, including salary freezes for certainly highly compensated individuals and salary caps for individuals making $3 million or more. There will be limitations on severance payments, stock buybacks, prohibitions on dividend and capital distributions, and the proceeds of the loan must be used to retain at least 90% of workforce at full compensation and benefits until September 30th, 2020. It's been reported that this program should be up and running in 2 to 3 weeks, and we will publish some additional client advisories on our website relating to the Main Street lending program. I'm going to transition briefly to some tax benefits under the CARES Act. The one that's gotten the most attention is the employee retention credit. There are 3 main rules that you need to consider. One is you need to continue paying wages, and you need to be an eligible employer, and you need to pay eligible wages. The benefit is that the employer can take a 50% credit of qualified wages limited to $10,000 per employee. There was guidance issued by the IRS last week, a frequently asked questions document. There's actually very beneficial to employers that indicates that the credit could be used to offset against the employer's portion of FICA and also the employees, and also it could be used to offset federal income taxes withheld. So it is very generous in terms of providing a credit or even a refundable credit under certain circumstances. Eligible employers are businesses that have stopped operating due to orders from a governmental authority or have suffered a significant decline in gross receipts, which is a decline of more than 50% of the gross receipts from the prior year. The qualified wages, if you have greater than 100 employees, these are wages that are paid to employees not providing services because of the government shutdown. Or if you have fewer than 100 employees, you could be paying wages either to people not working because of the government ordered shutdowns, or people you're paying and you've suffered a significant reduction in your business. If you take out the PPP loan, you are not eligible for this credit. And then a few more quick hitting items. The CARES Act allows you to defer the payment of payroll taxes. So any payroll taxes that would have been due on or before December 31st of this year, half can be deferred into the end of 2021, half can be deferred to the end of 2022. There are more generous provisions now relating to net operating losses, and there's been a glitch that's been fixed relating to how qualified improvement property is characterized. This is property that you put into place into property that you don't own. So if you're a lessee, for example, a restaurant, and you have a big build out, these are the types of things that are now eligible for 15-year depreciation, more importantly, bonus depreciation. So if in the last couple of years, you've made leasehold improvements that have to be amortized over 39 years, you can now go back and amend your returns and take a refund claim for the reduction in your income tax based on bonus depreciation. I would highly encourage you to go back through your prior tax returns with your accountants and figure out what benefits you might get under the CARES Act. Thank you, George. I'm sending it back to you.
Thanks, Adi. I'm next going to turn over to my colleague, Holly Goodman. She's a shareholder in our employment and labor law practice and litigation practice in the West Palm Beach office. And she's going to speak about employment issues and consideration from the CARES Act, as well as additional labor and employment topics that are relevant for in-house counsel and outside lawyers. Holly?
Thank you, George, and good afternoon. So there's been a lot of questions raised within the last couple of weeks since the CARES Act was passed, specifically addressing the impact on employees and the relationship between businesses and their employees. So what I thought would be useful here today is for me to touch on at a high level some of the questions that we've been getting on this issue. And then of course, when there's time later, if there's additional questions, you can put them in the Q&A function and we'll try to address them then. So the first thing that has really come up with respect to the CARES Act is how to determine whether or not you have fewer than 500 employees. Companies who are on the cusp of that threshold, we've been seeing questions about whether or not if they lay off or furlough a few employees, can we bring our numbers below 500 to be able to submit our application and take advantage of the PPP? And the answer to that seems to be no. As of right now, the Act itself doesn't really define when the number of employees is going to be measured, but existing SBA regulations state that they will consider the average number of employees over the preceding 12 months. So an immediate layoff right now isn't likely going to bring you under the threshold to be able to take advantage of the PPP unless there's been other things that have been happening within the last 12 months that might be able to help move that average. And of course, that really makes sense from the public policy standpoint, that the whole point of the PPP from Congress's point of view was to keep employees employed. And so they don't want to incentivize companies to be laying off or furloughing employees, because that then defeats the purpose of the loan to keep salaries getting paid. So that raises the question of whether or not you should apply or a client should apply if they're close to that 500 threshold. And what's really important here is what Adi spent quite a bit of time going through, and that is those certifications that you're going to have to make, that clients have to make before submitting their loan application, and that there are some pretty stiff penalties if you don't, if you make a certification knowingly, if you knowingly make a false certification. So you want to make sure that you've taken a full look at the average number of employees over the last 12 months to determine whether or not you're going to fall under that 500 threshold. And of course, there are a couple of exceptions to that 500 employee number, specifically for NAICS Code 72 for food and accommodations, hotels and restaurant chains that have multiple locations. Then they look at whether or not you have more than 500 employees at a single location. So there are some exceptions there to be aware of, especially if your businesses fall into one of those NAICS 72 coded businesses. So then one thing that Adi did touch on a little bit there as well is there's a lot of businesses who are coming to us right now and they say, but what's going to happen to us because we've already furloughed employees or we've already laid off employees? How does that affect our application? And while you can still apply for the loan, you do have to make that certification about using the money to fund payroll. And there will also be a reduction in the amount of the loan that can be forgiven based upon any reductions in your full-time equivalent headcount or in employee pay. So as Adi mentioned, 75% of the loan must be used for payroll costs. That'll include salaries, wages, commissions, the cost of healthcare coverage, retirement contributions. One thing that they have made clear is that that does not include payments to independent contractors, and that's because sole proprietors and independent contractors can put in an application for their own loan. So they don't want there to be double dipping for those same individuals. So you cannot use it for independent contractors. It's only to be used for US-based employees, and you will not be able to get forgiveness for any portion of it that's used towards your federal employment taxes or for any portion of it that's used to pay the Family First Coronavirus Response Act leave. If you have employees out on that paid sick leave, you're entitled to the tax credits, but you can't double dip. So you can't get the tax credits for the FFCRA leaves as well as use the PPP for those payments. You can only do one. So when looking at the reduction specifically on the amount of loan that is eligible for forgiveness, there's two things with respect to employees that are really going to come into play here. And the first is a reduction in the FTE headcount, the full-time equivalent headcount. So what's interesting here is that not a whole lot of employment laws really address FTE. They talk about employees in general, which is how the 500 employees is calculated based on full-time, part-time, straight headcount. But for the purposes of determining how much of the loan is going to be forgiven, they're going to look to the full-time equivalency. Now, those of you who are familiar with the Affordable Care Act and have done those analyses for your businesses, for your clients, on whether or not the Affordable Care Act applies will recognize the FTE concept, because that's really the only other law where we see the FTEs in full force in the employment realm. And so really, typically the way that that's calculated is to take the number of employees, the hours that the employees have worked, and divide that by a base number of what a full-time employee should work. There hasn't been guidance out on this yet. We are expecting there to be additional guidance to be issued with respect to the loan forgiveness piece of this. And so they have not yet, the SBA has not yet come out to say whether or not they'll consider it to be a 30-hour-a-week full-time equivalency or 40-hour-a-week full-time equivalency. For those familiar with the Affordable Care Act, it is 30 hours under the ACA. So the way that you calculate a full-time equivalent is that you take all the hours worked by the employees in a week and you divide it by 30 or 40, depending on which one the regulations end up pointing us to. And that gets you your full-time equivalent headcount. So from that perspective, you can have two part-time employees whose hours, when combined, equate out to one full-time equivalent employee. So that's how they're going to look at overall headcount. And what's really important about this is that that analysis is also going to capture a reduction in hours, because if you have the same number of employees, but you've reduced the hours that they're working, the full-time equivalency headcount is also going to be impacted by that analysis. So we need to be careful and make sure that you're watching out for the guidance as that's forthcoming on the loan forgiveness piece of it, because that may end up offsetting the amount of the loan that could be forgiven. Of course, for employees who have been fully furloughed or who have been laid off, or if you've had a reduction in hours, there is an opportunity for you to be able to rehire employees to get the headcount back up, or readjust those hours back up to fix that FTE if there's a concern about wanting to make sure that you can maximize your loan forgiveness. For employees who are fired or who quit, I've seen some companies are concerned, some businesses are concerned about what that's going to do to their FTE. And it's true that there doesn't seem to really be a distinction in the law here as to why employees have left. They're really just looking at your headcount. So we encourage you, if you do have employees who have been terminated or who have quit, to try to replace them as soon as you can, or to otherwise try to increase hours to cover that FTE. Now, there's also another way that the loan forgiveness can be reduced based upon how you handle your employees, and that is a reduction in wages. So a reduction in employee pay that's greater than 25% is also going to result in a reduction of the amount of the loan that's forgiven. It does not apply for employee compensation that's greater than $100,000, that 25% cap. So the way that they'll do this is that they'll compare wages in the covered period to wages in the last full quarter prior to the loan to see if there was a reduction greater than 25%. So again, if employees have taken a pay cut, you have the opportunity to correct that before you apply for loan forgiveness to try to offset that and maximize your loan forgiveness. So what if your employees found other jobs and don't want to come back? That's a question that we've heard as well. With the federal subsidy that's being given under the CARES Act for state unemployment, there are companies that have lower wage workers who are concerned about the fact that some of their staff and employees could be making more money on unemployment than they were making for the company because of this extra $600 a week federal subsidy. So, but one of the things that you can do, of course, is one, you can hire new people. So if you do have employees who quit, you can hire new people. But two, those employees also need to understand that their options are going to be limited. If they quit their job or if they refuse to return, if you have a furloughed employee that you've reached out to and said, hey, we're ready for you to come back because we have this PPP loan, those employees are not going to be eligible for unemployment. You will still have the opportunity to challenge the unemployment payments just like you would any other unemployment situation. And the reason here being that the employee had work available and quit if they didn't have a good reason to do so. So that's another way that employees hopefully will be incentivized to stay with the company and keep your FTE headcount up. So the final piece here is under the CARES Act. I alluded to some of the unemployment benefits. Of course, a lot of businesses right now are rightfully concerned about their staff. And so if you don't take the PPP loan, we've gotten a lot of questions about how to make sure that a company is really taking care of their employees if they don't receive the PPP, or after the PPP runs out, what exactly are employees getting if we have to lay them off or furlough them. In Florida, the state maximum benefits are up to $275 a week. There is a $600 per week federal subsidy through July 31st. So that makes the maximum weekly benefit available to employees. It puts them on an equivalent of basically $42,000 a year because they are eligible for up to $275 a week from the state plus that $600 federal subsidy bump. The benefits have also been expanded to individuals not otherwise generally qualified. So we've heard a lot of questions about people who are concerned about their independent contractors, their 1099s, because you can't include them in your PPP. And a lot of independent contractors and small solo practitioners are having a hard time getting PPP loans because their existing financial institution is not a SBA lender. And so one thing that is important here as well is that unemployment compensation benefits under the CARES Act have now been expanded to individuals who are not otherwise generally qualified. So that specifically includes people who have previously exhausted their unemployment benefits, new workers who maybe don't have the work history that's required under state law to be eligible for benefits, and independent contractors. So for those who are concerned about their independent contractors, make sure that they are aware that they can still apply for Florida unemployment benefits right now based on this expansion under the CARES Act. So, but again, the key here is that your employees cannot quit to be qualified for benefits. That could also get them into trouble. So make sure that if you have staff that you think might be better off under the employment system than they are working for you, do what you can to try to incentivize them to stay with the company because they may think that it's better off if they quit and apply for unemployment, but that may backfire for them. So to the extent that you can really take care of your employees and keep them incentivized to keep working for you so that if you have your PPP loan, you can maximize that headcount and maximize that loan forgiveness. And then just generally to try to retain people so that when we get through to the other side of this pandemic, you still have a strong workforce. Of course, if there are any specific questions that I didn't address, go ahead and put them in the Q&A box, and we will try to get to as many of those at the end as possible. But for now, George, I'm going to send it back to you.
Thank you, Holly. I appreciate your discussion. We're going to now turn it over to our colleague, Bob Lamb. Bob is a specialist in corporate governance, and he's going to talk about SEC guidelines and relief for public companies as focused on in-house counsel and what they need to know. Bob?
Thank you, George, and good afternoon to everybody. We hope that you're staying safe and healthy. Given our very limited time today, I'm just going to touch upon some highlights. We've posted and distributed e-alerts on much of what follows and other announcements by the SEC, the New York Stock Exchange, and other officials. If you haven't signed up for these e-alerts, please do so, or you can also check our COVID-19 landing page that George mentioned before. Our first topic is the SEC's extension of filing deadlines. Most recently, the SEC provided for a 45-day extension for many filings under Sections 13, 14, and 15 of the Securities Exchange Act of 1934. That covers 10Ks, 10Qs, proxy materials, and 13D and G filings. Notably, it does not cover Section 16 filings, transactions by insiders in company securities. Part of the reason for that may be that the SEC has expressed concern with regard to insider trading during this very sensitive period of time. We'll get back to that later. The relief is available for filings otherwise due through July 1, extended from the earlier date of April 30. It's not clear whether there will be additional extensions at this point. The extensions are not automatic. To qualify, a company has to file an 8K by the original due date of the filing, explaining why a timely filing cannot be made, the estimated date by which the filing is expected to be made, and specified other information, including if material or risk factor addressing the impact of COVID-19 on the registrant's business. There are other requirements and conditions, so it's important to focus on the details. I apologize for that tinging, but I can't seem to stop my computer from doing it. Another important topic for calendar year companies, and one that has generated an awful lot of discussion and concern, is the impact of COVID-19 on annual meetings that take place for calendar year companies around this time of year. First, the SEC has issued some significant interpretive releases clarifying that a company that does not, clarifying that a company does not have to mail supplementary proxy materials to its shareholders if it changes the date or time of its annual meeting or switches to a virtual meeting after mailing its proxy materials, as long as it issues a press release, files additional materials with the SEC, and in air quotes, takes all reasonable steps to notify proxy intermediaries, such as solicitors and tabulators. A different set of considerations applies to companies that have not mailed their proxy materials. However, many companies have included language in their proxy materials indicating that they may switch to a virtual meeting and telling stockholders where and when to find out the details. Thus far, this approach seems to be acceptable to the SEC. When considering what to do with your clients' annual meetings, it's critical to note that the ability to conduct virtual meetings and the conduct of the meeting depends upon state law and provisions in corporate bylaws and other organizational documents. So it's critical not to assume that it's a slam dunk. In addition, some states have issued emergency provisions on the subject. For example, the governor of Delaware issued an emergency order last week impacting Delaware corporations that decided to switch to a virtual meeting after mailing proxy material. Again, the SEC release contains certain expectations regarding conduct of virtual meetings, including the presentation of shareholder proposals. And as noted, state law can also impact how virtual meetings are conducted. Next, the SEC is has provided relief from certain paper filing requirements, including filings under Rule 144, manual notarization requirements for SEC Form ID, which is necessary in order to get EDGAR codes, and temporary relaxation of the rules governing manually signed materials. Here, as in other cases, the devil is in the details, so it's important to read the SEC materials very carefully. Last and definitely not least, Since the onset of the pandemic, the SEC staff, as well as Chair Jay Clayton, have issued a number of statements reminding companies of the critical importance of disclosure and maintaining market integrity, including the following. First, the importance of disclosure on the impact of COVID-19 on the company's business and operations, including financial condition, results of operations, and supply chains. It seems reasonable to assume that the SEC, as well as the investing public, may be dissatisfied with general disclosures that don't address specifics for public companies. As I mentioned before, the SEC has expressed on several occasions concerns about market integrity, including compliance with Reg FD and related insider trading concerns. Among other things, some SEC releases have noted that stock buybacks and transactions by insiders may be inappropriate if material information about the impact of COVID-19 has not been made available. A third area is the need to disclose where the company stands vis-a-vis financing, including the need for federal bailout funds or other sources of cash, such as Adi had talked about earlier. Notably, this statement by SEC Chair Clayton included an admonition that until a company is in a position to provide disclosure, it needs to keep a tight lid on the information. And those words were his, not mine. Most recently, last Wednesday, SEC Chair Clayton and Corp Fin Director Bill Hinman issued a first-of-its-kind public statement focusing companies on the upcoming round of first-quarter earnings releases and conference calls. In this statement, they urged companies to focus on forward-looking information and noting that, again, this is a quote, historical information may be relatively less significant than in the past. Some of the statements that I've alluded to and quoted from here suggest that the SEC may be giving greater scrutiny to Q1 earnings releases, MD&As, and other disclosures, as well as transactions by insiders, possibly with an eye towards enforcement proceedings. That's it in a nutshell, George, so I'll turn it back to you. Thank you.
Thank you, Bob. I'm going to turn it over now to Jonathan Osborne. Jonathan's the last of our presenters today. He is a shareholder in our business litigation group here in the Fort Lauderdale office and is a former federal prosecutor. Jonathan is going to speak to the topic of local closures, local ordinances, and executive orders and how they impact businesses across the state of Florida, how the executive orders from the governor impact businesses across the state of Florida, and how the differences in these orders impact essential workers and business functions. Jonathan?
Thank you, and good afternoon, everyone. Thank you for joining us today. As George mentioned, I'm going to talk this afternoon about a few things. The first is how Governor DeSantis' executive orders provide an umbrella of provisions and a definition of essential services that apply statewide. And if you've been following the news, you'll know that the executive order covers the entire state and that local counties and cities have enacted additional provisions that implement the governor's order in some ways and in other ways provide additional restrictions. So starting out with the governor's order 2091, which entitled Safer at Home, provides a definition of essential services. The governor's order relies on the list of essential services defined by the U.S. Department of Homeland Security, as well as a series of orders that were enacted by Miami-Dade County in March. The governor has provided a list of all the essential services that apply statewide on the floridadisaster.org website. That list is also available on Gunster's COVID-19 resource page. In the days after the governor issued his order, several counties, including Miami-Dade, Palm Beach County, and Broward County, clarified additional restrictions that apply to businesses in those specific local jurisdictions. I want to note two things about the local ordinances. The first is that these rules and regulations are changing overnight. And your business, if it operates, or your client's business, if it operates in multiple counties, could be subject to different rules depending on the cities in which they operate. The second thing I'll note is that the ordinances on the local level overlap in some ways, they conflict in some ways, and in other ways, they've created ambiguities as to what businesses are allowed to remain open and to what extent. In our representation of Gunster clients, we've had the ability and the opportunity to confer with state officials and county officials to help clarify the rules to the extent that there's ambiguity as it relates to any particular business. And so now I'll talk specifically about the Miami-Dade County order. Miami-Dade County's most recent order, like both Palm Beach County and Broward County, now have a provision that the employees as well as the customers who visit essential services that are still open are required to wear face coverings when inside the store. And that is a relatively new development in all of the South Florida counties. In addition, in Miami-Dade, essential businesses are required to limit capacity and to monitor their entrances. And Miami-Dade, like Broward and Palm Beach, also have provisions in place suggesting that companies that provide essential services have dedicated staff as well as hand sanitizer and other disinfectants available for customers when they are on the premises. Miami-Dade has a specific rule in place that actually applies to hotels and motels. In Miami-Dade, hotels and motels are precluded from allowing any occupant who does not meet the county's definition of an essential lodger. Broward County recently, on April 10th, issued a new executive order that applies specifically to Broward businesses. The order suspended Broward's previous order, which was number 2001, and like many counties throughout the state, has expressly incorporated and adopted the governor's list of essential services and businesses. So to the extent that Broward does not issue a subsequent change to its order, Broward County's ordinance does not currently place a limitation on hotels. Something else that is interesting about the Broward County most recent order is that it allows all businesses to perform what are defined as minimum basic operations, but the Broward County order acknowledges that such activities may not be expressly authorized by the governor's Safer at Home order. Broward County's guidance specifically says that if there is a gray area, if there's an ambiguity about how its rules apply to your business or to your client's businesses, they should consult with their attorney. And as I've said, in the instance of Gunster clients, we've been able to work with and consult with state and local officials to clarify any ambiguity as it relates to our clients' businesses. And lastly, Palm Beach County's latest order also limits new reservations for hotels, except the Miami-Dade County order limits all potential guests who do not meet the definition of essential lodgers. Palm Beach County limits new reservations for what are deemed to be non-critical lodgers. And one other thing to note about the Palm Beach County order is that it recognizes that the governor's order has made realtors an essential service. However, Palm Beach County order goes a step further to clarify that people in the real estate business cannot have open houses unless they are done remotely and using exclusively electronic means. Thank you, George.
On real estate brokers was actually a question we just had asked to us, so I'm glad that you were able to cover that. To further on what Jonathan was saying, realize that cities and counties can enact more restrictions than what the governor provided. The governor has come out and said that the executive orders that he has passed are a floor, not a ceiling. So you're seeing places like Miami-Dade County and individual municipalities, Broward County and others, who are putting in place more restrictions than what the governor did. And sometimes those restrictions are in conflict. So if you have particular questions about how your business can operate based upon potentially conflicting ordinances and executive orders, reach out to Jonathan and we can get answers to you for those questions. We're now going to turn to the moderated question portion of the webinar. If you've been submitting questions, we have them. If you have questions yet to submit, please do so. You can look at the question submission box on your screen to see the questions as they come in. So we're going to move into some of the questions that we've been asked, and I'm going to direct them to our presenters this afternoon who can best answer those questions. Let me start with Adi. Adi, there's a question on the affiliation rules for the Paycheck Protection Program. We've gotten lots of questions over the last few days and weeks about those affiliation rules. Can you discuss those affiliation rules for the folks who are tuned in today?
Sure. So, from a practitioner standpoint, I think the first important thing is to identify which affiliation rules actually apply for purposes of the PPP program. The Act and then the interim final rules make it clear that it's section 121.301F 13 CFR. So it's in the Code of Federal Regulations under the SBA regulations. But the thing that's a bit confounding is that what the Act says is that certain changes to those rules that were approved back in February are now rescinded. So what this results in is having a narrower rule base than the one that applied than you think might have applied. So in terms of determining affiliation, there's 4 major rules to consider. One is affiliation based on ownership. So if someone that owns your business owns more than 50% of your business, also owns more than 50% of another business, and in making that determination, the second rule is that you have to consider fully diluted stock. So you have to consider stock options, convertible securities, and other agreements. There can be affiliation based on management. So if you are the CEO of one business, you could be affiliated with another business of which you are a CEO or have significant operational authority. And finally, there's an affiliation based on identity of interest. So you could be affiliated with another business that's owned by a spouse, a child, or a parent. So when you work this all out, you need to carefully consider, are there any other businesses that are consolidated with your business for purposes of counting employees or revenue? What I was alluding to earlier that makes it a little more difficult is even minority owners can have certain management rights that may create affiliation. For instance, if as a minority owner, I have the right to approve loans or approve wages for certain employees, that may be sufficient management rights to affiliate me with another business that I may own, perhaps as a majority owner or as another minority owner. These are the issues relating to venture capital ownership or even private equity ownership, where there's some rights that are negotiated either in the charter or agreements among the parties.
Thank you, Adi. A question for Holly. As an independent contractor who is a green card holder, can I apply for a PPP loan and unemployment at the same time?
So the one thing to be careful about with the PPP loan and unemployment is that your unemployment will be offset by any amount that you do get paid through the PPP loan, because just like any other unemployment, any other time that you apply for unemployment compensation, they look at how much you're currently bringing in, and it may end up resulting in a zero net benefit for you, even if you are making a reduced amount now. So that is something to be aware of, that it may reduce the likelihood that you would qualify for unemployment if you do get the PPP loan, but there's nothing specifically that I'm aware of that would prevent a green card holder from being eligible to apply.
Thank you, Holly. This question is for Jonathan. Is there an ability, Jonathan, to submit waivers for orders of closure? Presumably someone who is not listed as an essential business now but wants to receive some kind of waiver or be listed in the future.
There is no specific provision provided in any of the local orders or an application process to submit a waiver. I know that in Broward County, the county administrator has basically invited businesses to speak with counsel. And I know in our own experience with Gunster, we haven't submitted any formal waiver, but we have approached the counties, both Miami-Dade and Broward County, when there's been ambiguity or where we feel that our client has a good shot at being included in what is defined to be an essential service, or in other instances, a business that doesn't interact with the public and as such should be permitted to remain open.
Thank you, Jonathan. This question is for Adi. What is the interplay of the CARES provisions allowing payroll taxes to be deferred and the PPP program? For example, if a company chooses to defer payroll taxes now, but receives a PPP loan in a month that is forgiven 60 days later, what happens to the deferred taxes? Do they become immediately payable, or does the amount deferred remain deferred? If taxes become payable, is it at the time of the loan or the time of the forgiveness?
So the short answer is that the payroll taxes that have been deferred prior to forgiveness remain deferred. And I would counsel you to look at the FAQ that the IRS issued at the end of last week that specifically provides that you can keep deferring payroll taxes until the loan is actually forgiven.
Thank you, Dee. This is for Holly. Can a solo attorney's independent contractor apply for either or both the PPP and unemployment if employment has been reduced but not stopped entirely?
The answer to that is yes. So the CARES Act does expand unemployment for individuals who are at reduced incomes, as well as individuals who have lost their employment entirely. So they can still apply for unemployment. And the PPP is going to look at the average they're going to look at a snapshot of what the average amount that independent contractor made last year, and determining how much to award.
Thank you, Holly. Next question is for Jonathan. Do employees in corporate offices in Broward County that are considered essential businesses but do not interact with the public, do the employees have to wear masks?
My understanding is for the businesses that do not interact with the public, that the recommendation, the requirement is that those businesses abide by the CDC social distancing principles.
Thank you, Jonathan. Next question is for Dee. These are two questions about the Main Street Lending Program. One, is it the same program as what was originally reported under Title IV? And two, under that program, is the eligibility 500 to 10,000 employees?
So the first answer is yes. This is the Title IV program, the Economic Stabilization Program. It's now called the Main Street Program, and it's subject to some of the provisions I mentioned earlier. The threshold is 10,000 or less, and the press release that the Fed provided with the initial term sheets and information indicated that PPP applicants are also eligible for the Main Street Program. So it's not starting at 500 employees. It's basically any small business subject to eligibility.
Thanks, Adi. This is for Holly. If an employer will not allow his employee to work from home due to COVID, and the employee's business is an essential business under the governor's order, can the employer dismiss the employee without any liability? Or if there is liability, what might that be?
There's going to be a whole lot of moving parts to an analysis on when you can or can't terminate an employee who isn't coming into work due to COVID. Some of that's going to depend on what kind of business you are, whether or not they have OSHA concerns, whether they've got PPE available to them. And importantly, given the governor's order that requires individuals over 65 or with certain pre-existing conditions to remain home, if the individual who's refusing to come in falls into one of those categories, then there certainly could be potential liability for terminating those employees under any of the anti-discrimination laws, or with respect to the governor's order under the Family First Coronavirus Response Act, which may offer those individuals paid leave options if they're unable to come into work and can't work from home.
Thanks, Holly. This one's for Adi. Does a solo practitioner who nets more than $100,000 qualify for a PPP loan?
The answer is yes, but I think that the amount of payroll that you can take into account as a solo practitioner would be capped at $100,000 plus benefits.
Another question, Adi, for you on the PPP. Question is, I understand that if employees were laid off or fired, it will affect the amount of forgiveness under the PPP loan. But what is the time frame? How far will they go back looking for fired employees? And what if they were fired for performance reasons not related to COVID?
So, to maximize forgiveness, and Holly touched upon this, you're comparing your full-time equivalents during the 8-week period following loan origination to 2 other time periods, one last year and one this year. So, the detail of your question would depend on whether that prior terminated employee was on the books during those other testing periods. If they were not, then it's not an issue. But if they were, as Holly alluded to, the test is, essentially a comparison of one set of average numbers of FTEs to another set. So that very well may impact you depending on when that employee was terminated. We need more details.
We have a question concerning the governor's order about how it interacts with his stay-at-home order interacts, or whether it supersedes local orders. The governor came out with that order, the stay-at-home order. The next day, he came out with a second order that had some language in there that talked about how it interacted. There was confusion as to whether or not the governor was saying that his order preempted. What the governor's order did was say what were essential in the state of Florida. The essential businesses were taken from the Miami-Dade County order, as well as an order from, or a designation from, the Department of Homeland Security as to what essential businesses are. But then the governor's office was quick to clarify that their order was not restricting local municipalities from doing more and putting in further restrictions. You've seen Broward County, as Jonathan mentioned, now having a wear a mask requirement for going into certain essential businesses. So that's the way they stand now. To our knowledge, there have not been any challenges yet to either local orders or executive orders. I suspect there will be challenges going forward. But right now, the two sets of orders, city and county and the state, are coexisting. Adi, a question for you. For EIDL application for a tech startup company, on the owner question, must they list all the friends and family shareholders or just 20% or more shareholders?
I'm going to base this answer about my review of the PPP loan application, but what they're asking for you to do is to disclose owners over 20% ownership. And those owners are the ones that are making certain certifications about, not have committed a felony and those types of restrictions. And so I think the same rules apply to the EIDL loans. They're both SBA loans, but I would double check on that. I think you're only disclosing the 20% owners, not the relatives of 20% owners.
And one final question, and this one also is for Adi. Question is, I'm with a business with over 500 employees. For the potential payroll tax credits under the first eligibility option, would the partial cessation requirement be satisfied simply because all of our offices are closed? We are still operating remotely, and we do not satisfy the second prong of 50% reduction in business receipts from the previous year's corresponding quarter.
So my read is that if you have more than 100 employees, the eligible wages are ones for employees not providing services because of a government-ordered closure. So if you're able to work remotely and you have more than 100 employees, then I don't think you would satisfy that prong.
Adi, thank you. Thank you to all of our presenters today, and thank you for being part of this webinar. Again, if you have additional questions, you can go to the gunster.com website. We've got two landing pages for you, /CARES-ACT and /COVID-19, which will provide you alerts and information that we've already gathered concerning both the pandemic, different issues concerning broader topics than we covered today, like force majeure and act of God clauses, business interruption insurance, and then the topics that we covered today as well. Remember again that this webinar will be available tomorrow on the website if you want to forward it to someone else. And again, if you have any questions, you can email them to us. Thank you for being part of this presentation.